Lovers of freedom all over the world, good morning, good afternoon, good evening. Depend on your time, wherever you're watching me from. Today's update is about Mr. Mazi Nnamdi Kanu going to court today. Let's hope for freedom. Let's hope for better tomorrow because he has suffered a lot. If you've not yet subscribed to my channel, please, what are you waiting for? Please run ahead and click the subscribe button, put it in all, like and share. Whenever I upload any video, you will be the first person to be notified. And to my old subscriber, thank you for being there for me. And to my returning subscriber, may God bless you all. Let's hope for peace. Let's hope for love. Let's hope for unity. Unity and freedom and peace. That is all we are looking for. Thank you guys for watching. Please stay tuned and enjoy this video with me. Give your own opinion. Leave your comment in the comment section and let me know what you think about this video. Thank you very much, guys. May God bless you. Bye for now. See you in my next video.
No, I won't link them once.
So, good afternoon. I can no price here. Yes. Page of final protest because the quality in the person but another touch.
Whose responsibility is it? One. Who's stopping them from Who's stopping them from coming out? I'm asking you, who's stopping them from coming in? I have a right. But I don't have a right. Well, who told them that? Who told you that? No, you commanding. Who is commanding? I can't command him. No, don't him commanding. No, don't commanding. Don't commanding. If you come to the what will happen? What do you think will happen? What will happen?
And not only be done, we manifest the same to be done. So we're in court to resolve this matter. Our big and gowns were inside the court. Our books were inside the court. Our bag we're just outside the court door. Because a number of us we are outside, we are not allowed to come in. So the court came in. Come and shoot us now. The court came in and they called up the case. Because the only case on the court. Call up the case. Ordinarily, it is the practice that when lawyers are not in court and when you are aware that they are weak and down, the court will naturally ask what are the lawyers, and they will tell you, do you know Mazi Nnamdi Kanu was in court. The Mazi Kanu was there, was in court, and our client was in court. We have seen him before them. But though the lawyers are outside, you have ordinarily summoned the legal counsel to find out from him what was actually going on. That has been the practice. So in a civilized society, that has been the practice in this country actually. I've not witnessed a situation whereby court will call in and call a case when lawyers in court in the matter were outside the court door. I've not seen such thing. So and when we were told that the court was about to proceed, we now struggle to go inside the court, the local stand. We are knocking at the door, the local staff, only for us to be told that the court called our client, called the prosecutor, and have a discussion with them in open court. So, taking us back to what happened on 26th of June, 2021, when he was talking to court with reference to us, and allowed to address the court. So, it's a clear case of denial of here. So, and the height of privacy of justice. This is what you are seeing now. So, if the court is not ready to go on with this case, what the judge, my lord, will have done is just to rescue herself from the matter. It's simple. It's allowed. Very simple. It's allowed. Instead of going about this way, because from what is playing out today, I don't think that the legal team, as we are today, still have implicit confidence in the court to go on. Exactly. We don't have confidence in the court again to go on with this case, and we're going to activate relevant administrative process to ensure that right thing is done. And this case, I can assure you today, this case will not get to January. It was the hard. And here, the hardest, just to see, we must activate the process to ensure that the matter is come up, is hard this week. He has not committed an offense to law. We have informed the world, filed our solid objection to the charge, that the 7-count amended charge filed against Nnamdi Kanu is as empty as what one can never imagine. It's as empty as what one can never imagine. It's a worthless paper before the court. And we have filed a strong objection to challenge it. and the court is under obligation to hear this application. Never really one more other. He can't run away from it. And no trial will commence in this case without application being had. Of course. So we're going to take up the matter in the court of action. Thank you so much.
Your name for the record.
It's very clear that the reason for the lockout. I've been here 5 times. My name is Bruce Fine. I'm an international lawyer who represents Nnamdi Kanu from the United States. It was clear today that they were, when the lawyers were entering the courtroom, when I was in there, they said, no, Mr. Fine, you can't enter. It's clear that it's the 5th time this has happened to me, despite the court order authorizing Nnamdi Kanu to see any lawyers of his choice without any inhibition whatsoever. It's a flagrant violation of international law. The Nigerian Constitution deprives an accused of right of access to counsel. It's very clear every single day that Nnamdi Kanu is being detained is another violation of international law. He's being punished in solitary confinement. There's never been any hearing whatsoever. Never been a finding that he did anything guilty whatsoever. And here he is. Now we have a scheduled hearing in January, 6 months of punishment before you even have a trial. Think of that. That's Alice in Wonderland. Sentence for his verdict afterwards. This case is going to go to an international forum. I'm taking the case to Geneva, the Working Group on International Arbitrary Detention, the International Criminal Court, and the International Court of Justice in The Hague, the United States Congress, to make clear that the Nigerian judiciary cannot be trusted. Sanctions are necessary in order to bring it into conformity with due process of law. And until that happens, Nigeria will be a pariah state. It will be a failed state. And I want to underscore to the Nigerian judiciary, you're not immune from criminal prosecution like the Nazi judges weren't either. You participate in the flagrant violation of human rights, you'll be charged with crimes against humanity at the ICC, and I can guarantee that because I'm going to do it. My name is Bruce.
Bruce Fine. Bruce Fine for record.
Bruce Fine.
Bruce Fine for record. Bruce Fine for record is a former deputy attorney general of the United States of America. Speaking to you.
Yes.
And a lawyer to Nnamdi Kanu IPOB in the United States of America.
Fine, right?
F-E-I-N.
For her to behave in this manner, I believe in Igbo language that is something that happened to people here and that make people to do that one sound. Not really. She wouldn't have done this thing. What happened today is a criminal trial in a secret manner. The lawyers were agitating that a particular person, they said that they don't want. We say no, it is not for your own to tell us who will come in and who will have given us 5. It is for us to say, Mr. Keko, Capo, Gold. Whether you like the person or don't like the person, it is our choice to say, these are the people that will come in. Not for you to start censoring those that will come in and those that will not come in. That is what that is the cause of whatever that happened. So as we were outside, deliberating in protest that we're not going to go in until they allow a representative from the United States of America to go in. The next thing is that the matter has been to 19th and 20th of January. And they have forgotten most important aspect of the Criminal Justice Act, which provides that if somebody is not granted bail, that trial must be day to day. That is the law. That is the law. We are not the one that make the law. It's when you grant the person bail, you can adjourn at your liberty. But provided that that person is under incarceration, the law says day to day. It has no need that you cannot try day to day. It must exist 2 weeks. So why you make the law? Why breaking the law?
Are you saying that the court has violated its own rules?
Its own rules and acts. The law is an act. That's the position of the law. And one of the Justice Act is there. So thank you, and thank you. We have a lot to do. God bless you.
Sir, you feel introduce yourself again, sir, your name.
By Instagram, Chairman Otokiwu on litigation and public interest.
Thank you very much.
Otokiwu.
Lawyers as they don't adjourn the matter enter January, then the next day they don't allow the legal counsel will come from the United States and they don't allow her make access the courtroom and the lawyers them they say waka come enter bbcpidgin.com to read more about the updates of this trial and how it will work out today.
Nnamdi Kanu, they had the trial today without
legal defense.
No legal representation.
No legal representation.
The court conducted proceedings of today of Mazi Nnamdi Kanu without legal representation.
So are we going to have justice?
No way.
There's no justice. You can see it. I've been shouting it. There's no justice. No lawyer was allowed to represent Nnamdi Kanu today.
I think it's high time.
So what do we do? And we still call it Nigeria.
Thank you very much.
We'll write a petition to NJC.
Thank you very much. Really,
Okay, let's organize ourselves.
that was our strategy. So I feel frustrated that an application that I'm
Sorry, sir.
today could not be had. The application was right.
Sorry.
The
Okay.
application was right to be moved. We are raising very strong objections to jurisdiction of the court in Nnamdi Kanu trial. Our objection is based on the following. The warrant upon which Mazi Kanu was arrested was issued by a federal high court in Abuja. Warrant of a federal high court in Nigeria is not valid for effecting an arrest in Kenya. Kanu did not undergo extradition proceedings in Kenya to the assumption of jurisdiction of a court over a fugitive suspect returned from overseas. So the condition precedent was not met. That's a challenge to jurisdiction. Then we have Article 12, Sub 4 of the African Charter on Human and People's Rights, ratified in Nigeria in 1979 and codified as part of our laws in 1983 that prohibits unlawful expulsion of Africans from one country to the other. And we have the continental counterpart that prohibits as such. It's our position that Mazi Nnamdi Kanu's exit from Kenya was unlawful expulsion that robs this honorable court of jurisdiction. So we are not talking only international law here. There's a misconception that, hey, Ejimako is talking about extraordinary rendition as if it's out of the blues. No, even our constitution prohibits extraordinary rendition. When the constitution said at section 35 that nobody shall be subject to arbitrary or unlawful arrest. What does that tell you? It means the constitution says extraordinary rendition even within the domestic territory of Nigeria is unconstitutional and is illegal. So at the arrest or what happened to Nnamdi Kanu in Kenya was arbitrary and unlawful. These are our positions and they are very, very clear. We have these Nigerian authorities to support all these things, and that is why extradition is important, and that is why United States, with all her military might, came to Nigeria. They want our top policeman, Abakari. They didn't take him by force. They approached the Nigerian government. They have the military, everything, but they are approaching our cause to issue an order that is called an extradition order or extradition warrant. So why didn't Nigeria respect Kenya? If Kenya cannot come to Nigeria and grab anybody and take them back to Kenya and subject them to trial, why should Nigeria be allowed to go to Kenya and grab anybody without authority of law?
Okay, sir. Okay,
and
sir.
Subject them to trial.
Sorry, sir.
So that is our case in chief.
What happened in court today?
What happened is that, I have said it before, we were outside consulting because there was a mild disagreement as to the number of lawyers that should be allowed inside the courtroom. So we left our books, wig and gown, outside and went outside. The judge had not come to put this together in a civil conference with DSS officers to resolve the issue of having lawyers that should go inside. Lo and behold, the judge came into the courtroom and ordered that we be locked out. We didn't know this. So somebody told us the judge is inside the room. So we broke up and went to the door to go inside the courtroom, but the door was locked. We banged. DSS officers banged. They refused to open the door. The judge proceeded to conduct ex parte hearing when lawyers are in court. A criminal defendant who was the nation since June in poor health, she conducted ex parte hearing and adjourned the case on her own motion to 19th and 20th of January next year. The law says this kind of case is day-to-day trial, that the maximum number of days or whatever period of adjournment allowed under the law is maximum is 2 weeks. So why this? We don't think it's fair. Justice should not be done, but it should be seen to have been done. Thank you.
Okay.
I think the government of the day want to...
I've interviewed you.
No, no. I just want to... The government of the day...
Lawyers, once we have over 10 members of SSS officials, let's inside the court. Why can't they allow at least some members of legal team defense to be in court? So they refuse to do that. And we are outside the court door trying to resolve these challenges. The court came in, locked the door, then denied access to the court. Before we could speak to Jack Robinson, the matter has been adjourned to the 19th of January. I've not seen such travesty. I've not seen travesty of justice. We are just told. We are told that they were invited, the court invited our client and the DPP and the prosecutor to have a discussion with them. Even when we are not there. Just like what happened on 26th of July, on 26th of June 2021, when he was taken to court without reference to us. And he was tried on that day without us being in court. It's the same thing the Deputy SPSF today. And it's unfortunately, we are within the courtroom. We are just outside the court door and we are locked outside. I've not seen such thing in my life. And there's no order from the court, substantial in court, stating that this trial will be called out in a secret. No such order has been given. This is the height of privacy of justice. So today, and also the court, and that's a John Dick, the court reviewed a guideline of persons who are visiting here. That guideline contained an order, you know, of course, and was served on the DSS. That order was flooded by the DSS with impunity. And to commit it to content, that application is going to come out today for hearing too, because we want to find the court. The court has a duty to protect the sanctity of this order. So we are in court today to also inform the court that the order he made and served on the DSS was flooded with impunity. He can't continue that matter. So today, we are not even allowed to come inside the court to address the court on this point. So what you are saying as legal team, there is a clear case of denial of fair hearing as concerns potential parties of the constitution. So we are going back home to strategize and take a further decision as to whether we can continue in this court or elsewhere. Because what we know is that this matter must be heard and must heard what? Expectation. Must heard expectation. If the court is not willing, disposed to hear this case, he will excuse himself voluntarily from continuing with this hearing of this case. That's what I can have to say.
Yes, what I want to say is it's very clear this was the 5th time I had come from the United States as Nnamdi Kanu's international lawyer to try to meet and see him, where I was denied 5 times. It was very clear today that I was the one that caused them to lock everybody out of the courtroom, including the kidnapping, extraordinary rendition, punching him without any trial or hearing, denying him access to his lawyers. These are all violations not only of the Nigerian Constitution, but international covenants to which Nigeria is a signatory. I am taking now the case to the international forum and tribunals. It's clear that the Nigerian tribunals are hopelessly complicated. It isn't even close to fair due process. And so I'll be going to the working group on arbitrary detention and the International Criminal Court and the International Court of Justice in The Hague, the U.S. Congress, to impose sanctions on Nigeria until it conforms to international institutions. I have seldom seen such open, notorious lawlessness. I underscore it is very clear. They signaled out me when I was the one who was approaching to enter the courtroom and said, Mr. Fine, you will. And that is exactly what ought to happen because the law does require that he go free. And the international community now is obligated to put the sunshine on the Nigerian judiciary and ensure that if justice is not done, there will be a price to pay. The judge herself may be subject to prosecution before the International Criminal Court. Judges are not free from criminality. The Nazi judges that implemented the Holocaust decrees against the Jews, they were prosecuted at Nuremberg. And if the Nigerian judges follow suit, they similarly are going to risk prosecution.
Your names are?
Your full name, sir? My name is Bruce, B-R-U-C, Fine, F-E-I-N. I'm from Washington, D.C. This is the 5th time I've been here in the last several months.
Okay, thank you, sir. Thank you.
Let me address you on behalf of Move to this side, sir. Sent a large delegation of Ohanese and the Igbo traditional rulers. Esoteric trial cannot stand this day and age. Lawyers and judges all belong to the same procession. And to this we say we want justice and nothing but justice. Nnamdi Kanu was so free. That's the subject.
All right, thank you,
I
sir.
am Chief Godwin Wazirike. I'm a lawyer.
to Ohaneze. Thank you.
All right. The hearing of our objection to the competency of the judge and jurisdiction of the court to hear the matter. But court today, we were in court for this we are in court in good time. And because of the constraint we are usually exposed to from time to time, the constraint that stems from the fact that lawyers are not being allowed access to the court. So we were there to resolve this issue. Because just